you have an alcohol problem, and you are one of those people who cannot drink alcohol whatsoever. If you continue this vein, what's going to end up happening is you're going to end up either killing somebody or you're going to end up in prison. And no amount of children that you have to take care of is going to stop you from going to prison. Paul Trevino, can I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Grant Hardy for the defendant.
And are you Ruth Marisol Trevino?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Ms. Trevino, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor, I
Coun-
did.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Right. Court will find that the state is in compliance with discovery. Ms. Trevino, did you review court admonishments and defendant's waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand? All right, she's not a citizen?
No, Your Honor.
All right, has she spoken to an immigration attorney?
She has,
Yes,
Judge.
I know.
All right. All right, did you understand you're charged with driving while intoxicated third or more? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I do.
Did you understand by entering this plea, you were giving up those rights?
Yes, I do.
And did you intend to give up those rights and enter into a plea in this case?
Yes, I do.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Trevino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen?
No, ma'am.
Counsel, were you able to confer with immigration attorney?
I was not, Judge. She conferred with an immigration attorney outside of my presence.
All right. Ms. Trevino, did you have an opportunity to speak with an immigration attorney?
Yes, I have.
And did you speak to them about the consequences of entering a plea bargain agreement in this case?
Yes, Your Honor.
And did you speak to them concerning the implications this plea will have on your immigration status?
Yes, I'm very much aware.
All right. Do you understand that you could possibly be deported and not allowed reentry?
Yes, ma'am.
And are you aware that you could possibly be denied naturalization?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I do.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication. State recommends community supervision, and there's to be ignition interlock for half the term. Did you understand that to be the plea?
Yes, I understand.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be 10 days in the Bexar County Jail as a condition, 120 hours of community service restitution, the DWI intervention program, and VIP live. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, I understand.
Counsel, you need to sign. Oh, then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
That I'm guilty.
State, and you're pleading guilty?
Yes, ma'am.
State, any evidence?
Attachments, Your Honor.
You may be excused. Did you review the document entitled waiver and consent to stipulations with your attorney?
Yes, I did, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, she has 3 children and she's 7 months pregnant. She has not had a drop of alcohol since this incident. And she frankly she explains to me she's very eager to get help in dealing with her alcohol problem. So we would ask that the court honor the agreement and put her on probation as agreed.
All right. So I'll give her a choice. She can do 10 days at the Bexar County Jail, or she can do 30 days on GPS.
30 days in GPS.
Are you employed?
No, ma'am.
All right, that's going to be full GPS for 30 days. And I'll ask that the fees be waived. So the court will sentence you to 4 years in the prison, suspended and probated for 4 years, $2,000 fine, probated, ignition interlock for half the term, 120 hours of community service restitution. I'm going to order parenting classes. Once she completes parenting classes, the community service hours will be deemed satisfied. Full GPS for 30 days, waive fees in lieu of 10 days at the Bexar County Jail. Regular reporting by Zoom or in person, regular random UAs, a referral to felony drug court, TAP evaluation out of custody, field visits 1 time per month for 6 months, 120 sober meetings in 120 days. When's the last time you had employment?
About 8 years.
All right, how do you support yourself?
My husband,
Okay.
I'm a stay-at-home mom. My husband's the one that works, and I stay at home with my kids.
All right. There's to be no employment as a home health care provider or with minors. And probation, I'm not requiring her to be employed since she's married and she's a stay-at-home mom, but I'm not allowing her to supplement any of the income by being a home health care provider or working with minors. The DWI intervention course, Victim Impact Panel Live, DWI education. Probation, is there anything else? Yes, 1 per month for 6 months.
There's one matter I'd like to address, Judge.
Yeah. Yes.
With respect to the GPS, Judge, does the court have any objection to her going to doctor's appointment? She is.
Yeah,
after
she
all,
can go to
pregnant.
doctor's appointments.
Great.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor. I didn't understand.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I understand.
All right, we can go off the record. Obviously, you have an alcohol problem, and you are one of those people who cannot drink alcohol whatsoever. If you continue this vein, what's going to end up happening is you're going to end up either killing somebody or you're going to end up in prison. And no amount of children that you have to take care of is going to stop you from going to prison. Do you understand?
I understand.
You've been to court before on a driving while intoxicated with a child in your vehicle. So if you don't want to get clean and sober for yourself, do it for your children. Because what would end up happening is if you end up going to prison, I could be wrong, but usually guys don't wait for women when they go to prison. Women will usually wait for guys when they go to prison. And you're going to end up in a situation where it's going to be like hand that rocks the cradle. When you come back, somebody else is going to be taking care of your children and calling them mom. You understand?
I do.
So you had better get serious about your sobriety. All right? All right, good luck to you.
Thank you, Judge.
2024 to the offense of choking. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application. They're taking in consideration 2024 CR 008862. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, ma'am.
Any objections to the PSI report, state?
No objection.
No
Defense?
objection, Your Honor.
Have both parties had a chance to review the TAP evaluation, state? Defense?
Yes, ma'am.
Any objection to the TAP evaluation, state?
No objection.
Defense?
No objections.
Any witnesses, state?
No witnesses, Judge.
Defense, any witnesses?
No, ma'am.
All right. I'll hear argument then. State you're opposed?
We are, Judge. Given the defendant's criminal history, this is not the first felony that he's been committed or that's been convicted of. He has committed multiple acts of family violence, and one in October of 2023 was a choking and strangulation. However, that case was dismissed because the complainant waived prosecution.
And who was the complainant in that case?
It would have to check actually, Judge. He has been convicted of unlawful carry of weapon and assault in 2021, and I can check the victim on that one momentarily. He also has been convicted out of state, out of Wilson County for an assault second. He was given probation in that case. However, he did not complete his probation. He was revoked on December of 2023. And he is pleading to one case, which is the offense date of the 6th of June of 2024. It wasn't until he bonded out 3 days later, he committed another offense on June the 9th of 2024, also an assault second. Given his criminal history, given the fact that he has been given an opportunity to get probation in Wilson County and has been revoked, the state does not believe he would be a good candidate for probation. And we ask that you sentence him to no more than 10 years TBC.
Right. And while the state is finding the list of the complainant on the other cases, defense, I'll hear your argument.
Yes, Judge, defendant's been in custody for 168 days. He has no felony convictions that I know of. He has 2 children. He does need some mental health assessment. The complainant in the case, Megan Rodriguez, in the report states that she's in favor of probation. I think with the proper guidelines set forth and conditions that, that the probation recommends that he's learned his lesson. He's taken anger management courses, 12 of them. I'd like to give you copies
Any
of
objection
those.
to the court reviewing the certificates?
Okay.
So has spent his 168 days productively in custody and he's ready to return. He has to support his 2 children, needs to get back to work. And I think that any other conditions that you might give him that are outlined in the probation report, he's willing to follow your rules and not come back here.
All right, defense. I'm sorry, state.
Judge, to answer your previous questions on the first assault, the misdemeanor conviction was a different complainant. On the assault, choking strangulation that occurred on October 26th of 2023, where the case was dismissed for complaining waiving prosecution, was the same complainant as this case. It has a different last name, but I confirm it's the same date of birth.
All right. And then the case that you're taking in consideration, the ABI second, who's the complainant?
That one should also be the same.
All right. Is there anything you wish to say?
I'm very more.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. All right, so what was this argument about?
I can't even remember that day.
All right, because according to the stipulations, it states that the complainant was sick through food poisoning. and she asked for your help caring for your child, which was crying. And it says that you became angry with her. So she ended up taking the child and asked you to fix a bottle for the baby. You were still angry and you were upset with her requests. So she put the child down and went to get the bottle for herself. You wanted to leave the residence and tried to get the car keys. She would not give you the car keys, so you slapped her. She defended herself. You hit her in her chest, then placed your hands around her neck, choking her. So you don't remember any of that?
No, Your Honor, I was putting my daughter to sleep that night, and she had been in the restroom. I was having difficulty putting my daughter to sleep, and I had asked her to help me. She ended up picking up our daughter, and she started rocking her, putting her to sleep. After that, I was frustrated, but I wasn't trying to leave at that point. It wasn't until she had started getting physical that I was trying to leave. But at no point did
Well, it says here, the victim stated that she was strangled by her boyfriend. She sustained injuries to her neck and chest. While speaking with the victim, I observed scratch marks and redness to the left and right side of the neck and redness to the chest. I observed bruising to the left and right biceps and underneath both arms of the victim. And they photographed the injuries. I also photographed a large amount of black curly hair clippings that were in the bathroom allegedly left by the suspect prior to him fleeing the location.
I had cut my hair that day.
All right. Well, in the report, they make it seem as though you choked her and then you cut your hair and then you left.
That day, it's hard to recall that day, but I know that when she had started choking me, and
Oh, so you're saying she started choking you first?
yes, ma'am.
Okay. You may continue.
After that is I started going back at her, and I regret it deeply. It's just
Okay. All right. Any questions?
No, Your Honor.
State any questions?
Just a couple, Your Honor. Mr. Rodriguez, you are applying for probation, or you're asking the court for probation. Okay. So you understand that the first step of probation is accepting responsibility, right? But when you spoke with the probation officer when this report was being prepared, you did not want to talk about the incident, right?
I told the probation officer that I couldn't recall it fully.
Okay. So you did say that you had difficulty remembering, but then you also said that you'd rather not talk about
I didn't want to talk about it without remembering it fully.
it. Okay. But you do remember that she started it?
Yes.
Okay. How is that accepting responsibility if you're blaming it on her?
I'm taking responsibility for my actions. I shouldn't have reacted the way that I did. I should just walked out of the house once things started getting physical.
But you understand that you've been placed on probation before, right?
Yes.
And the idea is probation should give you the opportunity to rehabilitate yourself and avoid engaging in any more criminal behavior, right?
Yes, sir.
So you didn't complete probation in Wilson County, right?
No, sir.
Okay, and then you committed an offense on June the 6th, right? Of 2024? The choking?
Yes, sir.
And then again on June the 9th of 2024, right?
Yes, sir. Or June 9th, that day I didn't really do anything. I had OD, and my wife had called the cops saying that she needed ambulance.
No further questions, Judge.
All right. Anything else from the
No,
defense?
I think, Judge, the fact that he took these anger management courses shows that he wants to comply with the terms of probation if you give it to him.
All right, the court is going to deny your application, find you guilty. Does anyone wish to speak to the cap?
Judge, in light of the fact he has two children, he has a household that needs him, we request the cap be the minimum of 2 years.
All right, state, what are you requesting?
That's no more than 10 years.
All right. Mr. Rodriguez, I want you to know that I listened to the arguments of both sides. I listened to your testimony. I read the stipulations again because I'm not the one who accepted this plea. And I also reviewed the TAP evaluation and I reviewed the PSI report. This is what the court is going to do. Court is finding you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. Taking consideration 2024 CR 008862, there's to be no contact with Megan Lindsay Garza, no unsupervised contacts with minors. I'll recommend the therapeutic community for you. The therapeutic community does not increase the amount of time that you serve. For example, if I were to send you to 10 years, the fact that you're in the therapeutic community will not extend you beyond my sentence. Do you understand?
Yes, sir.
I do not have jurisdiction to force them to place you in the therapeutic community, so you'll have to request it. But it will show in your judgment that the court is requesting the therapeutic community for you to address any drug or alcohol issue or any mental health issues. And the court will sentence you to 6 years in the prison. Did you review the document? Yes?
Would it be possible
Here.
to get the no contact order dropped?
No. And let me explain to you why. I don't like for people to think that I just do things just to do things. For example, giving 6 years instead of 10, there's a reason for that. I took in consideration the mitigation evidence. I took into consideration what the complainant wanted, and I took into consideration your criminal history, and I took into consideration the classes that you completed. With regards to the no contact order, there's an issue here. And that issue hasn't been solved because this is not the first time that you were accused of assaulting her. This is the first time that I guess she's given a statement to the police about it and come to court about it and continued with it. So obviously that relationship is not working. I don't have you on supervision with the court because I'm sending you to prison. If I had you on supervision, I would still have the no contact order, then maybe slowly consider lifting the no contact order. But not in this case, the answer will be no. All right, so that's 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
You signed.
Yes, Your
All
Honor.
right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I know 6 years is a lot of time. It's a lot of time away from your children, but you can't continue to commit actions that you commit, violent actions, and then not expect there to be any consequences. When you're released from prison, if I'm still here, you need to make sure that you take care of your drug issues and you take care of your mental health issues. If you cannot find a place, come back here and I will pick up the phone and call someone to help you. You understand?
On my release, I plan on going to CHCS, Center for Healthcare Services.
Okay,
So
that's
I'm gonna
great.
Get my primary care doctor back on medication.
All right, awesome. Make sure that you stay on top of that, okay? Up to you.
After hearing everything, the choking, the photos of her bruised neck, the past assaults, and even his failed probations, the judge makes her final call. 6 years in prison, no contact with Megan, and a strong push into the prison therapeutic community to deal with his anger, drugs, and mental health before he ever sees his kids again. This is what happens when violence becomes a pattern, not a mistake. Was 6 years justice, or still too light? Tell me in the comments, and don't forget to like, share, and subscribe for more courtroom breakdowns.
All right, court is calling 2022 CR 8245 and 2022 CR 3008, State versus Mark Anthony Aragon. Can I have parties announced for the record for the state?
Megan Gavel, state.
Robert Mauer for defendant, Your Honor.
And are you Mr. Aragon?
Yes, ma'am.
All right, off the record for a moment. Excuse me, sir, you're gonna have to find a seat for security reasons. Thank you. All right, we're back on the record. And each cause number, you entered a plea of guilty. The court ordered a TAP evaluation and PSI in each cause number. This was actually set for a hearing, but your client was a no-show. And so a warrant was issued for his arrest. And cause number 2022 CR 8245, according to the plea bargain agreement, the state is silent on your application. There's to be restitution to express super Gs. This is to run concurrent with 2022 CR 3008. And in that cause number, according to the plea bargain agreement, punishment is to be assessed at 3 years in the prison, and the state is silent on your applications. Have both parties had a chance to review the PSI report? State?
Yes, Judge.
Defense?
Yes.
Any objections? State?
No, Your Honor.
Defense?
No.
Have both parties had a chance to review the TAP evaluation? State?
Yes, Your Honor.
Any objections?
No, Your Honor.
Defense?
Yes, no objections.
All right, state is silent. Defense, do you have any witnesses?
Judge, on my client's behalf, I'd ask the court to consider granting his application for probation. And if the court decides that's not appropriate, I just ask the court give him credit for time served and honor the plea bargain.
All right, is there a reason why he didn't show for court at his sentencing?
I have no explanation, Judge.
All right, would you like to say anything?
I had just lost my job and
No. I mean, if you want to say something, you can say something, but you're going to be placed under oath. And if it's something that is factual, the state will be able to ask questions in regards to that. So do you wish to say anything?
No.
All right, then in cause number ending in 8245, according to the PSI report, they have a restitution amount of, I believe, 2,500. Is there an agreement to that restitution amount?
No, Judge.
All right, other than their request of that amount, state, do you have any documentation?
Judge.
Because in the PSI report, I just see where they're saying tanks were stolen and they state it's for $2,500, but there's no receipts or anything of that nature.
Yes, Your Honor. Checking on our online system to see if that's been uploaded to discovery.
No problem. And while she's reviewing that, and cause number 2022 CR 8245, the court is going to deny your application. Court will find you guilty. The court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 3008. And any update, state?
Didn't see any receipts uploaded, so.
All right, there's going to be restitution to express super Gs. And the owner is listed as Raul Garcia. There's to be no contact with 227 Enrique Barrera Parkway or Express Super Gs. Anything else in that cause number with regards to sentencing?
No, Judge.
And then in cause number ending in 3008. The court is finding you guilty. Sentence you to 3 years in the prison. give you credit for any time served. And this will run concurrent with 2022 CR 8245. Anything else in that cause number with regards to sentencing?
No, Judge.
All right, and each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because these are plea bargaining agreements, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record and state you're excused. Here's the thing, and I'm sure your attorney will tell you this. Yes, I review people's history, but the number one thing you must do, if you have sentencing, you have to show up. Who knows what would have happened? Maybe I would have given you probation, but the fact that you don't show up combined with your criminal history, that's a recipe that tells me you're not going to do well on probation. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you, Judge.
Thank you, ma'am.
All right, so who's the prosecutor on this one? So supposedly a pending murder case or something?
I think we never really got a clear answer. So detectives definitely talked to him, but if there's no charges coming down, I really don't want to keep holding it up. I mean, it sounds like he may possibly be witness, but I don't have
Okay,
anything.
so
to
we
show
need
that
a
he's
jury
suspect.
trial.
That's what I'm thinking, Judge.
All right. And I'm assuming you're not ready today.
No, and I'll tell you, I'm out the last 2 days this week. I have to
Okay.
do the mandatory max CLE, and then I have to do the mandatory juvenile law CLE. And I have a doctor's appointment Wednesday, so it's gonna make it very hard
No
to
problem.
get this in this week.
All right, Norma, I need a jury trial date on Anzadua for January.
No,
No,
it's
criminal
regular.
trial division.
Yeah.
All right, and he needs to be brought over dressed.
We'll get them close. I don't know if we got you close yet or not. I'll be starting a file.
All right, so and I need the acknowledgements of discovery done if that hasn't been done.
Will do, Judge. He's remanded without on one case and filed a motion to set bond. I think it's still working its way through the e-filing system.
All right, if y'all are ready to proceed on it, we can proceed on it.
We're ready to go. I mean, he got remanded due to a subsequent arrest. We're just asking the court set some kind of bond.
All right, which case is that on?
Give me just a second, Judge. I'm trying to find it for you. Hold on. You remember which one it was off the top of your head? Late filing thing. Was he evading? Yeah, I think you're right, actually. It was an evading arrest, Judge. Evading arrest in a motor vehicle case, Your Honor.
All right. Well, we have two evading arrests. Well, we have the evading arrest detention second or more,
I believe it was the one in the vehicle.
the vehicle.
Yes, ma'am.
All right, are you ready to proceed on this motion?
Yes, Judge.
Thank you. The whole website's done. Okay, I made the one still.
All right, court is calling 2024 CR 3794 State versus Joshua Anzadua. Could I have parties announced for the record for the state?
Megan Gavel for state.
Adam LaHood for the defendant, Your Honor.
And are you Joshua Anzadua?
Yes, Your Honor.
All right, defense has filed a motion to have bond set in this, but of course, with e-discovery, it is somewhere in the ether, yes, or in the time continuum, somewhere lost. Any objection to proceeding on the motion orally state?
Oh, Your Honor.
All right. So defense, you're requesting a bond?
We are, Judge. He was on bond, and then there was a subsequent arrest, a case which we tried to resolve via plea, but I think we're headed to trial on it. Due to the subsequent arrest, he was remanded without bond, which would make it impossible for him, obviously, to be released from custody. We're asking the court to either reinstate the bond or set some bond in some amount that gives him any chance. Obviously, while he's remanded without, he just simply has no opportunity at all to post a bond, Judge. And for that reason, we're asking the court to set a reasonable bond in this case.
All right. And what amount are you requesting?
Your Honor, due to, and it is without the bond, and just so we're clear, it's in the cause number ending in 3794. Previously, I believe his bond was 10,000? 10,000. We understand there's consequences for the rest, Judge. We would be okay if the court set a bond at 20,000, which would essentially be double what the previous amount was.
State?
Judge, we request a $50,000 bond, given that original charge, the offense date was November 23rd of 2023. There were multiple other subsequent arrests, well, the subsequent arrests, but it's multiple offenses that stemmed out of that additional arrest, and for that, and because of the criminal history as well, that is the reason that we request that.
All right, what is the defendant's criminal history?
Sentenced on a possession of controlled substance, PD 1 grams.
And what date was that? Or the date of the offense?
Offense date was in 2019. He was awarded probation in that, but ultimately he was sentenced in 2020.
All right, and the cases that he has open in this court? What?
Judge, he does have one more case that he was sentenced on.
Mhm.
It is a bird have intent to commit assault. That offense date was in 2020, January of 2020, and he was sentenced September of 2020. The offenses that he has pending in this court include the instant offense, the evading arrest.
Please make sure that's off. Yes, you may continue.
With the vehicle, 2 assault peace officers, 1 possession controlled substance, PG 1 to 4, an evading detention, 2nd and more, theft. Well, then he has 2 misdemeanors pending, a theft 100, 750, and criminal mischief 100.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Joshua Antaldua.
All right. Sir, have you ever been diagnosed with any mental health issues?
Manic schizophrenic.
All right, and have you ever received medication for that?
Currently on medication right now for.
All right. And then if you were released, do you have a place to live?
Yes, ma'am.
And that place where you would be living, is that equipped with a landline phone?
Yes, ma'am.
All right. Do you have any children?
A 2-year-old, I believe, that I just barely found out about.
All right. Has there ever been any drug use in your past?
Yes, Your Honor.
And what would that be?
Methamphetamine.
And how often in your past were you using?
Occasionally.
What does occasionally mean?
Almost every day.
All right. Any questions from either side?
Nothing from the defense, Your Honor.
All right. Do you want to question him about the amount of bond he can make? Yeah. All right. Who has that phone? All right. Do you know how to turn it off?
I'll assist that.
All right. Thank you so much. They keep coming out with newfangled ways with the phones, and it's hard to know how to turn them off. Do you want to question him with regards to the amount of bond he can make?
Yes, Judge. So, Mr. Ansaldua, are you working right now?
Not at the moment due to incarceration.
Okay. Before you were incarcerated, where were you working?
At Garcia Foundation.
And how much were you making? Either were you paid by the hour, by the day?
By the day.
How much are you making per day?
$80 a day.
$80 a day?
Yes, sir.
Are you able to go back and work there if you are released?
More than likely.
More than likely? Okay. What do you have any substantial savings right now?
Not at the moment.
What about family, mother, father, brother, sister, people that could assist you?
Yes, mother.
Your mother? If you've talked to her, do you know roughly what total bond amount you could possibly make? Okay.
We'll be able to make something.
Okay. But you have talked to your mom about the possibility of getting out or her helping you post bond?
Yes, sir.
All right. And is your mom retired or working?
She's working.
Where does she work at?
She's a CNA.
CNA? Oh, like certified in nursing?
Yes, sir.
Okay. All right. We'll pass the witness, Judge.
All right, any questions?
Just briefly. So when you were on bond previously, was it your mother who posted your $10,000 bond originally?
Okay.
Okay, who was that?
My girlfriend?
And you said that your mother works, correct?
Yes, ma'am.
And has she made any efforts to secure bonds in any of the other cases where bond was set?
No, ma'am.
And I guess if you're released, are you going to be living with your mother?
Yes, ma'am.
And is that in a house or an apartment?
A house.
Does she own that house?
Yes.
And how long has she lived at that residence?
About 3 years.
Nothing further on it.
All right, this is what the court is going to do. The court is going to set your bond at $30,000. There's to be partial GPS. The court will waive fees. And the partial is for employment and mental health appointments. I'm going to do a referral to Center for Healthcare Services, outpatient treatment, outpatient drug treatment, waive fees.
Thank you, Your Honor.
All right, Ms. Ferguson, if you can make sure that he has a reset form, please. All right, thank you.
Thank you, Your Honor.
Just a second.
Who's here on Randy Wayne Folsom?
After getting remanded with no bond for a new evading arrest in a vehicle, Joshua finally gets his shot in front of the judge. She digs into his record, his meth use almost every day, his mental health meds, and the fact that his mom, a CNA, will take him in if he's released. In the end, she sets bond at $30,000 with GPS monitoring and orders outpatient drug and mental health treatment instead of just warehousing him in jail. Was this a smart balance between public safety and second chances? Drop your thoughts in the comments, and don't forget to like, share, and subscribe for more real courtroom breakdowns.